Toronto, Canada's top court is set to decide on Friday whether children who have lived in Canada for years should be forced to go back to Germany where their father lives. The case turns on such matters as how much say children should have when their parents' relationship sours, and what constitutes their habitual residence. The Office of the Children's Lawyer maintained both the initial judge in the case and the Ontario Court of Appeal failed to take into proper account the views and interests of the children in their decisions. Parental intentions and actions were prioritized over the perspectives and lived reality of the children, the children's lawyer argued in written materials filed with the Supreme Court of Canada. The goal of deterring abduction and protecting the interests of children generally was prioritized over the rights of the individual children before the courts. The case involves John Belev and his wife Catherine Rose Baggett, both Canadian citizens, who were married in Canada in 2000 and moved to Germany in 2001. Their two children, also Canadian citizens, were born there in September 2002 and December 2005. The family lived in the European country until Baggett and Belev separated in 2011 and he was given custody. However, they agreed Baggett would take the children to Canada to attend school, and he signed a letter transferring custody temporarily to her. The mother and children left most of their belongings in Germany when they returned to Canada in April 2013. Belev began trying to get the kids back, but Baggett refused. He revoked his custody consent in March 2014 and began court proceedings in Germany under the Hague Convention, an international treaty that seeks to protect children from cross-border abductions. The German court ruled that children should remain with their mom in Canada, but an appellate court decided Germany lacked jurisdiction because the children were not German citizens and were living in Canada at the time. The court also decided Canada had become their habitual residence. Belev pressed his case in Ontario. In April 2015, a Superior Court judge in St. Catharines, ONT, ruled the children's habitual residence was in Germany, a fact that had not changed during the time they spent in Canada. The judge ordered their return to Europe even though the Office of the Children's Lawyer said neither child wanted to go back to Germany. On initial appeal in Ontario, Divisional Court reversed that decision after finding the children's usual home had changed to Canada even before their mother had refused to allow them to go back to Germany. The court also found the Hague Convention did not apply. The Ontario Court of Appeal quashed that finding. Writing for the court, Justice Robert Sharp said he had considerable sympathy for Baggett's contention that it would be better for the children to stay in Canada, and that moving back to Germany would be difficult given that the kids had been in Ontario for several years. Nevertheless, the court ruled the children would have to go back to Germany on the basis the German-born children were normally residents there and their mother had violated the Hague Convention by moving them. The court also found the children's objections to going back, too much homework there and losing friends in Ontario, were insubstantial. In addition, the court ruled the father would have to provide suitable housing for the mother and children in Germany. The children's lawyer turned to the Supreme Court of Canada, saying the children had ended up being harmed by the operation of an international convention meant to protect them.